Citing ethical concerns, the special prosecutor heading up the John Doe is now calling on at least one and possibly as many as four of the justices to sit this one out. Justices who've all benefited from huge amounts of money spent on their behalf by some of the same groups directly involved in the John Doe case they're about to rule on.
It just doesn't pass the smell test.
Matthew Rothschild is the executive director of the nonpartisan Wisconsin Democracy Campaign, an organization that's been tracking the so-called dark money flowing into state Supreme Court races.
Wisconsin Club for Growth spent $350,000 to help Justice Roggensack get elected. Wisconsin Club for Growth spent $400,000 to help Justice Ziegler get elected. Wisconsin Club for Growth spent $500,000 to help Justice Gableman get elected, and spent $500,000 to help Justice Prosser get elected.
That's unregulated conservative money flowing exclusively to conservative justices, at least one of whom was reelected by the slimmest of margins.
I have enormous confidence in our election system.
In 2011, David Prosser defeated Joanne Kloppenberg by just 7,000 votes.
You had outside groups spending 5 times as much money to help Prosser get that seat than the Prosser campaign itself spent. And these outside groups are the subject of the John Doe.
In 2009, the U.S. Supreme Court declared that in situations like these where the dollars are high and the election's close, judges should recuse themselves. But a year later, in 2010, the Wisconsin Supreme Court adopted its own rule, one that seems to fly in the face of that federal decision. It says that a contribution alone isn't enough to warrant recusal. And that rule, by the way, was drafted by one of the groups targeted in the John Doe, the Wisconsin Manufacturers and Commerce.
I am deeply concerned about it.
Former Chief Justice Janine Geske says that ethics rule should be changed, making recusal mandatory when big money is either given directly to judges or, as in this case, spent on their behalf.
Because not only would that be a reason for recusal, it would discourage people from spending that money. Because if they thought a justice that they like is not going to be able to hear their case, they won't give the money.
She'd also like to see retired justices brought back to replace those who might have a conflict, something that would enable the court to maintain its quorum and its integrity.
We'd have to amend our Constitution to allow that to happen, but I think we ought to do that.
Money can stifle speech.
Geske and Rothschild both point to the U.S. Supreme Court's Citizens United decision as laying the groundwork for this particular dilemma, a decision that famously said corporations are people and money is free speech.
Citizens United really, I think, in my view, has deeply attacked and affected our democracy in this country.
Pretty soon, you're going to have Wisconsin Manufacturers and Commerce, Club for Growth, the biggest corporations in Wisconsin or the richest individuals in Wisconsin, essentially purchasing the best Supreme Court that money can buy. And it's a great investment for these corporations because the court will then rule in favor of the corporations. But it's a terrible investment for democracy and for impartial justice.
We did try reaching out to the justices directly to get their perspective on this apparent conflict, but they are refusing to comment.